Is the judicial system functioning? We've looked at the construct of the criminal mind, the role of the TTPS, their crime fighting initiatives, and what is being done to properly detect and solve crime. Now let's wrap our heads around the workings of the judicial system and functionality in Trinidad and Tobago. Master Murray-Bailey, thank you for joining me at this conversation today.
Thank you for having me.
Tell us, what are some of the responsibilities of a master in the criminal justice system?
Well, with the passage of the Criminal Division, District Criminal and Traffic Court Act, a Criminal Division of the High Court of Trinidad and Tobago was created. And this Criminal Division is based on a bifurcated system. So what that means is that criminal masters are responsible for pre-trial case management, while judges are responsible for trial and trial management. Also, criminal masters deal with bail applications, applications for variations of bail, as well as soon with the implementation or the proclamation of the Administration of Justice Indictable Proceedings Act, we will find that preliminary inquiries are abolished and the masters will be dealing with sufficiency hearings. And the purpose of the sufficiency hearing would be to ensure that sufficient evidence exists so that we can establish a prima facie case against the accused person.
And does that mean that preliminary inquiries will no longer be active?
That is the expectation, that with the proclamation, preliminary inquiries will be abolished and matters will come straight to the masters for a sufficiency hearing to be conducted.
Now, oftentimes we hear that judges are creatures of statute. Can you please explain this to the layperson?
Well, judges aren't creatures of statute, but district court judges are creatures of statute, and what that means is that they get their powers as well as their jurisdiction from the creating statute or the creating legislation, and so therefore they are required to operate within the four corners of that statute.
And could you tell us what is bail and how does bail come about basically?
So bail is an important aspect of our system. When an accused person comes before the court, he's charged with an offense. The first aspect of it is dealing with bail. And so the first consideration, of course, is what is the purpose of bail? I will start by telling you what bail is not.
Right.
So bail is not meant to punish anybody for any crime that is committed. That's not the purpose of bail. The purpose of bail is to ensure the attendance of the accused at his matters, or the defendant at his matters, and that's the purpose of bail. And so as a matter comes before the court, the first thing that the court has to remind itself is that the Constitution is actually the first piece of legislation that we look to determine how we treat with an application for bail.
And when you say the Constitution, how does that determine bail?
Well, the Constitution actually provides that a person who's charged with a criminal offense shall not be deprived of reasonable bail without just cause. And in addition to that, of course, the Constitution also provides that someone is presumed innocent until proven guilty. So from the very onset, when someone comes before the court for bail, what we find is that there's a presumption in favor of bail, in addition to which there is a presumption of innocence.
Of course. As we're on the topic of presumption of innocence, now, of course, when someone pleads guilty, what sort of sentencing does the court have jurisdiction over?
Well, it all depends. Every matter is case specific. And so when someone pleads guilty, we have to think about the aims of sentencing, first of all. And of course, there is a sentencing methodology. The one thing that persons may not know is that sentencing is not at all arbitrary. There is actually a sentencing methodology that all judicial officers are required to follow. And this is what we fondly call the Aguilera principles. And so there is actually a calculation that takes place. So just to explain those Aguilera principles, the first point is a calculation of the starting point. This is where we consider the aggravating as well as mitigating circumstances in relation to the offense. So that first stage of the Aguilera principles, that's where we speak about the objective aspect of it. You look at the offense. What is the nature of this offense? Is this a serious offense? Is it not a serious offense? Is it an offense that is very harmful to society or not? So those are the kind of questions we ask, and then we calculate the starting point. After calculating the starting point, there is an upward or downward adjustment when we consider the offender himself. So this is when we look at the offender, and the offender that comes before you is a person. So here, we look at factors that are pertinent and personal to this offender. This is a more subjective aspect. What is the age of this offender? Does this offender have any previous convictions, or is this a first-time offender that's coming before the court?
Yes.
And all of those factors are factors that are personal to this person. And this is where the human aspect of it comes in. So we look and we listen to everything they say in mitigation to get a sense as to who is this offender that is actually before the court. Thereafter, there is another adjustment, as you said, for a guilty plea. So where someone pleads guilty, there is a further discount from the methodology, a further discount in terms of the sentence. And then lastly, if there is any kind of pre-trial custody, any time spent in pre-trial custody, that as well is subtracted from this sentence.
And what about remorse? If a victim, if a perpetrator exercise remorse,
yes,
for their crimes, do the judges also take that into consideration?
Definitely. That is definitely something that is taken into account. The expression of remorse is something that, many perpetrators come before the court and they say that they are remorseful, and there are sometimes persons who are able to indicate that their remorse extends to the point where sometimes, of course, case specific as always, they wish to pay compensation to the victim. So sometimes in those circumstances, there is remorse that is visible in terms of the payment of compensation as well. But even in sentencing, as we take into account this offender, if this offender actually expresses remorse, it is something that the court considers.
And then you spoke about discount.
Yes.
Discounting of sentences.
Yes.
Could you just explain what
Yes.
type of discounts can one get?
Well, you usually can get a 1/3 discount for a guilty plea. If there is any kind of departure from that 1/3 discount, the judicial officer is expected to explain why there may be a discount, so that you can't just pluck out of your head and decide to not discount for a guilty plea. It must be justified as to why you are not giving this discount. But generally speaking, a discount of about 1/3 is given for a guilty plea.
Gift giving during a lockdown can still be hassle-free with a gift from FanZone with delivery options available nationwide. Visit and browse our Facebook and Instagram pages for all your official licensed merchandise and apparel, and have it delivered to your door. Find us on Facebook and Instagram. FanZone, we've got you covered.
A reminder from WESN. We urge you to protect yourself and others from the spread of COVID-19. Stay safe by taking some simple precautions. Clean your hands often. Use soap and water or an alcohol-based hand rub. Practice social distancing. Stay 6 feet apart. Wear your mask. Don't touch your eyes, nose, or mouth. Cover your nose and mouth with your bent elbow or a tissue when you cough or sneeze. stay at home. If you have a fever, cough, and difficulty breathing, seek medical attention. Following the above can help us all to help each other.
Yes. And what is the court view on restorative justice in the criminal jurisdiction, of course?
It plays a very large role, especially now in the criminal justice system. The whole concept of restorative justice and that whole concept is dealing with matters in a very different way, I think, than we've been accustomed to dealing with criminal justice matters previously. This is where you look at the harm and making reparation for the harm that has been caused. This is where you bring persons together and you try to find a way to repair that harm to society that crime causes. And so it plays a very large role in the criminal justice system.
So is it an alternative to custodial sentencing?
It depends. As I say, all of it is case specific, and so it all depends on the circumstances of the case. So for example, we recently, like last year, you would have seen that there was a piece of legislation that was passed that spoke about a referral to drug treatment court upon sentence. And so it can be that there is a referral, or it can be that there is sentencing. So it all depends on the matter that is before the court.
Right. And can a master rule from a place of teaching the perpetrator of crime a lesson?
Well, as it is right now in terms of sentencing, masters aren't sentencing. As I said, the criminal division of the High Court is based on a bifurcated system. So right now, masters aren't the ones to determine guilt or to at this point, sentence someone. When a JIPA comes in, that's going to be, which is the Administration of Justice Act, that is going to be a different story. But in terms of generally a judicial officer ruling from a place of, can you repeat it? A place of? Of
teaching a lesson.
Teaching a lesson.
Teaching a lesson.
Well, I would answer the question by saying this. There are different sentencing aims and objectives, and in taking into account the sentencing aims and objectives, one such aim is a deterrent, the aim to deter. And so deterrent in relation to the offender that is actually before you, as well as deterrent in relation to persons who are looking on. So this is where the sentence must reflect a situation where the crime doesn't pay. And so it is in those circumstances, when you're taking into account the sentencing aims and objectives, that you think about the need to deter the offender himself, as well as other persons looking on would-be offenders.
Now, of course, you know the maxim, justice delayed is justice denied. And for far too long, persons on the outside have been clamoring for a properly effective justice system. What is the judiciary doing to ensure that cases are disposed of efficiently?
Okay. To answer the question, I think the delay must be placed in context. Historically, this delay has been based on the fact that the criminal justice system, as simplistic as the answer may seem, the criminal justice system is overwhelmed and has been overwhelmed in the past. And what that means is that there are various agencies and departments that were not properly resourced in order to meet the needs. The way I look at the criminal justice system, it is almost as if it is akin to the human body. And so there are these various parts of the human body that work and they are interdependent, and similarly with the criminal justice system. So if I were to give you an example, for example, of a matter that comes before the court, the magistrate's court, for example, possession of arms and ammunition or possession of a firearm, an accused person is charged with that. When that person is charged, there are various arms of the state that are responsible for that delay, yes? And so someone has to bring the person to the court. And of course this was pre-COVID, if the person does not come to the court on time, there's a delay. If the person is charged with possession of firearm and ammunition, that exhibit then needs to go to the Forensic Science Center. If there is a difficulty there, there's a delay. A prosecutor needs to be appointed. If a prosecutor is not appointed on time, then there's a delay. Of course, if the accused is unrepresented and he wants legal aid, there is a delay in terms of the appointment of legal aid. So I say all of this to say that the judiciary is but one arm of the criminal justice system. And so what we have seen over time is various legislative as well as institutional alignments which have come into effect to strengthen the criminal justice system as a whole. The judiciary now specifically, what the judiciary has done is ensure that its own institutional alignments are put in place so that it is more efficient and effective. So you will have the passage of certain pieces of legislation which have assisted that. So I spoke of previously the Criminal Division Act.
Yes.
There's also the Family and Children Division Act. So what has emerged is a divisionalized judiciary. So you have the Civil Division of the High Court, you have the Criminal Division, and then you have the Family and Children Division. With that divisionalized judiciary, what has come into play is a case flow management that is now differentiated. So what that means is that you find that there is an efficient and effective disposition of matters and dealing with matters from its initial inception of the matter, where the matter is filed, to the eventual disposition. And that's in terms of the case flow management. Now, in terms of specifically case management and trial management, I would have spoken previously of the bifurcated system. Now, what that does is to make sure that when a matter comes before a master for pre-trial management, that matter must be prepared to the extent that when it gets before a judge, there can be no delay. So, for example, I deal with everything that deals with disclosure. Any kind of issue that may come up within the trial, if there's fresh evidence, a fresh evidence application that needs to be filed, any issue with the exhibit, all of those matters are dealt with at the master's level. So by the time the matter goes to trial, there's a seamless process, there is very little delay, and therefore matters can be dealt with faster. In addition to that, the criminal procedure rules actually give us the powers and the opportunity for cases to be managed in a more efficient way. These criminal proceedings rules actually give us the opportunity to identify matters early, intervene in matters early, as well as dispose of the matters in a very efficient and timely manner.
Yeah.
So because of that, you're actually finding now that we have the tools to manage matters more efficiently, as well as have the administrative support to be able to have efficient case flow management.
But Master, you speak about the readiness of, or the delay, which is attributed to different arms of the system, where it be the attorneys, the prosecution. Now there's a great unreadiness in terms of the prosecution when it's time to be ready for matters, basically. How does the court deal with the unpreparedness of the prosecutions?
Well, I think it all depends. Again, it is case specific, and you need to understand why the prosecution is unprepared, which is why I took the time to explain the matters and how matters progress in the court. The prosecutor can be unprepared because a matter, the exhibit in a matter is not ready. If the exhibit is not ready, then the matter cannot be tried completely. So if, for example, I'm dealing with a matter, I cannot say that this is a firearm. Forensic Science Center must say it's a firearm. And so we have to delve into what's the reason for prosecutors not being prepared. Is it a matter of the prosecutor is required elsewhere in another court? What is the issue there? Depending on what the issue is, we are able to deal with it. So for me, the criminal procedure rules give us the opportunity to give case management directions without a hearing. so that in the event that the prosecutor is not there, for example, the prosecutor is in another court, I can still move the matter forward without a hearing or in the absence of the prosecutor. And so that is something that does not necessarily delay. And now, of course, we have ways of communication that are different ways of communication. So I can give orders via email,
yes.
And this prosecutor can respond to me, can file documents electronically. So because the prosecutor is not physically there, it does not mean that the case stops. And of course, again, because of the criminal procedure rules, we have the ability and the authority to still move the matter forward, notwithstanding a party does not come.
And then do you have the power to dismiss cases in that regard if they are not ready, the prosecution?
Masters do not have that power, but of course various judicial officers have the power when it comes to that. Again, AJIPA is not yet in force, which is a whole different conversation. In terms of what the powers are under that. But other judicial officers do. District court judges or magistrates, as we know, they do have the power to dismiss it. But of course, as with everything else, it must be fair, and the determination must be made, taking into account all of the circumstances of the case.
Seven is out, all day is in. WESN News on the hour.
Every day, we communicate through stories. Stories of ourselves, our challenges, our goals, our experiences, and our aspirations. Storytelling is an art that we have mastered. WESN Film Studios comprises a collaborative team of experts with extensive industry experience locally, regionally, and internationally. The ability of your business to successfully communicate with your preferred audience depends on the strength of the stories you tell. Your vision should be communicated in a high-quality, professional, and creative way. From concept to post-production, advertising to film, multi-camera productions, live events, streaming, and virtual conferencing, we are WESN Film Studio. Let your own unique voice be heard and your vision realized. Call us today at 628-5835 for your next production.
Master, with the advent of COVID, we've seen a lot of virtual, the judiciary would have converted to virtual hearing. How effective has that been to the judiciary?
I think it has been very effective, and the expectation, of course, is that virtual hearings will continue even after COVID. It gives persons the opportunity to attend court, persons who would not necessarily have had that opportunity before to attend court. I don't know whether you may know, but recently I made a decision in relation to electronic monitoring. And in making that decision...
First of its kind, of course.
First of its kind.
So they made history.
Yeah, so one of the things that I was able to do is to virtually view the home that the accused was going to stay at. So one of the aspects of the order is that the accused person was required to reside at a particular residence. And usually it would take some time for someone to visit the home, to check to see what the home looks like, etc. But I was able to virtually view the home. I asked the mother of the accused to turn her camera to walk around the house, to show me where he would be staying and what the facilities of the house would be. So it was was important to me as well that they had internet access. So she had to show that there was internet access. It was important for me to see that there was electricity, functioning electricity, because he would need as well, when he accessed bail, to join court virtually. So all of those things were possible because we were doing an electronic hearing. And so this is, to answer your question as well as the delay, this is how we cut down as well. I didn't have to adjourn the matter. No one had to pay a site visit. I could see with my own eyes as to what was taking place there. And I thought that is one example as to how electronic hearings really work.
And what about parties who are unrepresented in the virtual system?
Yes.
How is the court ensuring that they are given links or they are be able to attend via their telephone or their cell phone or whatever digital medium that they have?
Yes. It's important to note that from the beginning of a matter, we actually ask for contact information. So we ask for your cell phone number, we ask those kinds of questions. So we do have the information, even if it's not necessarily your cell number or your email address, the email address of a family member, someone that you can be contacted at. And when that information is sent, you can then join virtually from there. So we ensure that we have contact information. And to be honest, persons who are unrepresented have actually been very excited to be able to join virtually, because previously people would have had to take a day from work to come physically to the court. And now you see persons able to join from their desk sometimes in work, sometimes join from home, persons who previously would have had to send a message saying that they had childcare difficulties and could not come to court. You're now seeing them able to access justice. And that is something that I think only the virtual world could provide. So it has worked out very well.
And finally, Master, do you think that the judiciary is evolving in terms of access to justice for all?
I think the judiciary is evolving. I think one thing that everyone can note about the judiciary is that we have been listening. You know, some of the initiatives that you would have seen within recent time really point toward the fact that the judiciary is listening and trying to provide and providing the access to justice that persons need. So we do have virtual access rooms where persons who do not have access themselves can go to the rooms. And
it's also in the prison as well.
And this is also in the prison as well, where persons can access the justice system. Persons who previously may not have had the opportunity to access, they can now access the justice system. So I think that as we move forward and some of the initiatives are allowing persons who previously would have struggled in accessing to access. Not only that, but of course, persons who would have expressed difficulties in accessing the existing services, we've listened. So for example, we have persons who had difficulties paying maintenance, etc. You know, and they were, they didn't know what to do. I'm living on one side of the country. Every time I have to pay this maintenance every Friday, I need to take a day from work. I need to leave where I am to come into, maybe Port of Spain to pay this. And so you see that we have court pay.
Yes.
Attorneys have had...
That's a brilliant move.
Yes. And attorneys, for example, have had difficulties in terms of coming to the court to access their orders. They have to send someone to pay filing fees to do all of these things. And so we've seen court mail. So the one thing that we can be clear of about is that the judiciary is listening. We are working assiduously. We recognize that there are some difficulties, and we are working assiduously to really try to deal with these issues and ensure that persons have access to justice. Master,
any closing comments for the public in terms of the judiciary or what they should know? Coming soon, maybe?
In terms of the judiciary, I think what members of the public should know is that we are working really hard and believe in what we do. We're working really hard to ensure that persons have access to justice, that it is timely access, and that we are efficient and effective in our operations. And as time goes by, we will be able to even continue to show the effect of all of the work that we have put in.
Master Murray-Bailey, thank you very much, and we do appreciate you, and we do appreciate you taking the time to conduct this interview.
Thank you very much.